Hello friends, welcome to EPG Pathshala. I am Manvendra Kumar Tiwari and I am Assistant Professor at Dr. Ram Manohar Lohia National Law University, Lucknow. Today, as part of the Criminology subject, we will be talking about plea bargaining or sentence bargaining. Now, starting with the very concept of plea bargaining. Now, plea bargaining in its most traditional sense is a bargaining which refers to a bargain between defendants which happens in the pre-trial stage, usually conducted by the counsel and of the defendant and the prosecution, during which the defendant agrees to plead guilty in exchange for certain concessions by the prosecutor. Plea bargain is a contractual agreement between the prosecution and the accused concerning a criminal charge. The concept originated in the United States of America and gradually accepted in several other countries. In India, docket pressure and delay in disposal of cases is the primary reason for the acceptance of plea bargaining as a legitimate tool. And apart from this, overcrowding in existing prisons in India is also a reason for the incorporation of plea bargaining in India. Plea bargaining is different from compounding of offences as provided under section 320 of the Code of Criminal Procedure 1973. Compounding of offences is done pursuant to a decision by the victim of the crime to not press the charges any further. Compounding, therefore, has the effect of acquittal of the accused, whereas plea bargaining records the conviction based on the guilt confessed by the accused. However, both plea bargaining and compoundable offences are the kinds of offences which can be taken away from the ambit of crime to matters which can be privately resolved. Now, coming to the Criminal Law Amendment Act 2005. Now, the Criminal Law Amendment Act 2005 is the amendment by which the concept of plea bargaining was introduced in the Indian law. 2005 amendment inserted a new chapter, Chapter 21 capital A in the Code of Criminal Procedure. Thereby, it recognized the concept of plea bargaining. However, the concept of plea bargaining that is introduced in India is not akin to the existing plea bargaining practices which are going on in other jurisdictions. For example, the guilt plea is to be made by the accused before the court, and thereafter the court would order the negotiation to take place between the accused and prosecution, including the victim, only after being satisfied about the voluntary nature of the plea. Compared to this, in plea bargaining in its traditional sense, the plea of guilt is made before the prosecutor and not before the court by the accused, or for the process of bargain to commence, and the process of negotiation is largely outside the domain of courts. Indian law tries to guard against the influence which the prosecution can have upon the accused, and therefore differs from the conventional concept of plea bargaining. Now, section 265 capital A to 265 capital L of CRPC provides for the entire process of plea bargaining in chapter 21A. Plea bargaining is permissible only for offences which are punishable for imprisonment of 7 years or less, but it is entirely inapplicable to offences which affect the socio-economic conditions of the country. And the government of India, by way of a notification, has categorically stated as to what are these offences which affect the socio-economic conditions of the country. Apart from this, offences committed against women or a child below the age of 14 years are also outside the purview of plea bargaining. Now, coming to the process of plea bargaining. An application of plea bargaining cannot be filed by the accused who has already been convicted on an earlier occasion for the same offence. This is given in section 265B clause 2. An accused who is a juvenile or child as defined in the Juvenile Justice Care and Protection Act has also been kept out of the purview of plea bargain as given in section 265L. Beginning of the process. The process is set in motion by filing of an application of plea bargaining by the accused before the court where the trial is pending. After the filing of the charge sheet against him by the officer in charge of the police under section 173 CRPC, and in complaint cases after the issue of process against the accused under section 204 CRPC. This is the point wherein the process of plea bargaining is set in motion. The application filed by the accused must contain a brief description of the case relating to which the application is filed, including the offence to which the case relates to. The application must be accompanied by an affidavit sworn by the accused, wherein he must state and accept his guilt. Next stage in the process of plea bargaining is the stage of working out a mutually satisfactory disposition. The court must, after getting the notice, after getting the notice of acceptance of guilt from the accused, the court must issue notice to the public prosecutor or the complainant of the case, as the case may be, and the accused also to appear on the date fixed for the case. Thereafter, the court must examine the accused in camera. This is important because voluntary nature of the acceptance of guilt is something that is to be determined, and it is of paramount significance, and therefore the court must examine the accused in camera in the absence of other party to find out whether the application has been filed voluntarily or not. Only after being satisfied with the voluntary character of the application that the court must provide time to the parties for working out a mutually satisfactory disposition. A mutually satisfactory disposition in relation to plea bargaining would be a disposition wherein the prosecution would accept the plea of guilt of the accused, and the accused in turn would agree to pay a compensation amount agreeable to the prosecution. This would be the main content of the mutually satisfactory disposition. What is important is that a mutually satisfactory disposition would not include the sentence that is to be given to the accused in the event of prosecution and accused having agreed for resolving this matter by recourse to plea bargaining. The sentence, despite the recourse to the process of plea bargaining, is something that is still the prerogative of the court only. The court, subsequent to the reaching of the mutually satisfactory disposition by the parties, would decide the suitable sentence for the accused. Now, coming to working out of a mutually satisfactory disposition. Who are the parties to this working out of the process of working out of the mutually satisfactory disposition? In case of police report, a case which has emanated from a police report, the parties would be public prosecutor, the police officer investigating the case, the accused and the victim. In complaint cases, the accused and the victim and the complainant would be the parties. Accused, however, may participate with his pleader. This is provided in the provisor to section 265 CA and 265 CB. The court must ensure that the process of arriving at the mutually satisfactory disposition is also a process wherein the parties have acted voluntarily. So, voluntary character is not only something that is to be seen at the time of the proposal of acceptance of guilt by the accused, rather the entire process of working out of mutually satisfactory disposition, the court remains duty bound to ensure that the parties are acting voluntarily. Now, coming to the disposal of the case post the arriving at mutually satisfactory disposition by the parties. If suppose no such satisfactory disposition could be worked out, the court must record such observation and proceed further in accordance with the provisions of CRPC from the stage of filing of the application for plea bargaining by abandoning the process of plea bargain. So, the court would then commence the trial, which otherwise would have happened had the process of plea bargaining not intervened. But if a satisfactory disposition is reached, the court shall prepare a report to this effect signed by it, and all the persons who participated in arriving at the disposition would also sign on it. After this, the court can award compensation to the victim in accordance with the disposition arrived at, and subsequent to this, hear the parties on the question of sentence. Subsequently, the court may release the accused on probation if the case is one which either falls in section 360 CRPC or under the provisions of the Probation of Offenders Act 1959 or under any other applicable law allowing for probation. If the offence is the one for which the minimum sentence is provided in law, then the accused may be sentenced to 1/2 of such minimum punishment. If the offence pleaded guilty for by the accused does not fall in the previous two categories, then the court may sentence the accused to 1/4 of the punishment provided or extendable as the case may be, given under in section 265 capital E clause D. Moving on, set off. The benefit of section 428 of CRPC, which allows the setting off of the period of detention undergone against the sentence of imprisonment awarded by the court, shall apply in the same manner as they apply in respect of imprisonment under the provisions of CRPC. That means, if the sentence has been given, that sentence is to be, the period of that sentence is to be set off against any period of imprisonment already undergone by the accused. Now, thereafter, the court must deliver the judgment signed by the presiding officer of the court, including the compensation to the victim by the accused and the formula for sentencing is to be announced in the open court. The judgment delivered by the court is final, and it is amenable only to the special leave petition before the Supreme Court under Article 136 of the Constitution and writ jurisdiction of the High Court under Article 226 and 227 of the Constitution. This is given in section 265 capital G. The process of plea bargaining also ensures that the statement of facts stated by the accused in an application for plea bargaining is not to be used for any other purpose except for the purpose of plea bargaining under this chapter 21 capital A of CRPC. This would ensure that this would in a way induce the accused to come forward, as his acceptance of guilt would not be used outside the process of plea bargaining. Plea bargaining from the point of view of accused and the victim. Now, this is examining the niceties of the provisions of plea bargaining and its viability in the Indian context. Now, firstly, there is a possibility of collusion between the prosecution and the accused. Now, why do we say that? Now, we say that because in the process of working out a mutually satisfactory disposition, the prosecution and the accused, rather than actually arriving at a mutually satisfactory disposition, may actually arrive at an agreement, which obviously would not be a legal one, nevertheless would arrive at a consensus between the two sides, that rather than going forward with the process of plea bargaining, they would rather do it in a manner whereby the prosecution would deliberately weaken its case against the accused. This would ensure that the trial, which would take place since the mutually agreed disposition cannot be arrived at, in the trial the accused would be acquitted, and this possibility cannot be ruled out, and therefore this how to overcome this real possibility is something which remains a challenge. And in order to do that, as it often happens, an accused need not even file an application of application accepting his plea of guilt. In fact, this can happen altogether outside the criminal trial process. How to rule out this possibility of collusion between the prosecution and the accused is something that is very, very important, and perhaps one of the very significant reasons why we have a very low rate of conviction. This in itself is significant. In a country which has a very low rate of conviction, it seems difficult that the people would come forward accepting their guilt. They would rather hope that they would be acquitted than to presume that since they happen to be the real culprit, the likelihood of they being convicted is more, and therefore this poses an immense challenge to the viability of plea bargaining in India, wherein the possibility of acquittal weighs very heavily upon the possibility of conviction. Second, in relation to examining the contours of plea bargaining is the possibility of coercion of the accused, especially if the accused happens to be coming from a poor socio-economic background. In such scenario, if his free will is not there in the process of arriving at the mutually satisfactory disposition, though the court is given the responsibility to ensure that the process of working out of mutually satisfactory disposition remains voluntary, but this is something which cannot be absolutely guarded against, and therefore the possibility of a poor accused or accused coming from a poor socio-economic background actually accepting onerous proposals of the prosecution remains there, and how to rule out this possibility again remains a challenge before the task of implementation of plea bargaining in India. Law Commission in its 142nd report had also recommended no such plea bargaining despite accepting guilty plea and a corresponding reduced sentence. The court was of the view that in the Indian scenario, it is very difficult, difficult to actually ensure that the working out of the mutually agreeable disposition is something wherein the consent of both the sides are actually free. Now, coming to the judicial response. Now, so far as judicial response post the introduction of the 2005 amendment in the CRPC is concerned, the judicial response, there is nothing significant. It's mainly because of the scant resort that has been made so far to the process of plea bargaining by the accused persons in India. If lesser is the resort to plea bargaining, lesser would be the clarity in relation to the very working of the provisions of plea bargaining in India. Now, this again tells us the not so exciting story of plea bargaining, that it has not gained popularity in India owing to peculiar factors attributable to Indian justice dispensation system. In the past, when I say past, I am talking about scenario before the introduction of plea bargaining in India. Justice P.N. Bhagwati in Kasam Bhai Abdul Rahman Bhai Sheikh versus State of Gujarat, this is a 1980 Supreme Court judgment. The court in this case, speaking through Justice P.N. Bhagwati, made a very important observation regarding plea bargaining. It said, "It is to our mind contrary to public policy to allow a conviction to be recorded against an accused by inducing him to confess to a plea of guilt on an allurement being held out to him that if he enters a plea of guilty, he will be let off lightly." The court then went on to say, such a procedure would be clearly unreasonable, unfair and unjust, and would be violative of the new activist dimension of Article 21 of the Constitution. Now, this is very important. You have an observation from the Supreme Court declaring the process of plea bargaining wherein an allurement is held out to the accused as a quid pro quo to he having confessed to his crime is something that has been declared contrary to public policy by the Supreme Court, as well as it being violative of the Constitution of Article 21. However, it is important to know that these are not these observations do not form part of the ratio, as no such law was actually there which was to be actually examined in that case. So, this remains an observation in the realm of an obiter dicta, and furthermore this should also be not taken in the contemporary context because this happens to be an observation made before the introduction of plea bargaining in the Indian law in the year 2005. Moving on. In Muralidhar Meghraj Loya versus State of Maharashtra, again Justice V.R. Krishna Iyer, while disapproving the giving of a sentence lesser than the statutory minimum sentence on the basis of plea bargaining, observed that this aspect of criminal justice deserves Indian jurists' consideration. So, there appears to be some kind of acceptance of the idea of plea bargaining in this observation. However, with a circumspect view that this is something which remains to be considered, and the fact that this is something which remains to be considered perhaps is also reflective of the fact that the court is, in this case at least, is not viewing it as something which is contrary to Article 21 of the Constitution. Now, finally, to the conclusion of our today's discourse, the actual working of plea bargain could have been better understood in India if it would have been resorted to very frequently. As I said earlier, that the resort has been very less, and therefore we are not in a position to actually understand the true working of the provisions of plea bargaining. the lesser number of cases that have gone to plea bargaining, especially if we go into the percentage of cases that have been decided in India so far by way of the process of plea bargaining, the 2015 data shows that in the year 2015, out of all the criminal cases that were disposed of by the court, only 0.45% of the cases were actually disposed of by way of plea bargaining. So this in itself is reflective of the poor state of affairs so far as the popular acceptance of the concept of plea bargaining in India is concerned. Less than 0.5%, that less than 1% and less than half of that is only 0.45% of the cases were actually disposed of. Now, this realization again in a way rebuffs the very concern that was rejected by the Law Commission of India in its 142nd report, wherein it has said that a country with such high acquittal rate, why would people in general opt for plea bargaining? Law Commission in that case had not considered this to be an option which would militate against the idea of incorporation of plea bargaining, but this the realism of plea bargaining in India in the modern in contemporary times perhaps proves the fact that this high rate of acquittal is something which is coming in the way of its popular acceptance. This therefore remains a challenge, how to make the process of plea bargaining actually work in the sense in which it was envisaged by the Parliament when it introduced the concept in the year 2005 in the Indian law. Thank you.